Thank you very much. I'd like to call this meeting to order. Roll call.
Treasurer Dios,
Here.
Dean Rondo.
Here.
Mark Carullo.
Here.
Mike Cicerone.
Yeah.
Joseph Cortigo.
Here.
Matthew Howard notified me he would be absent today. Yan Lee notified me that she would be absent today. William Murray.
Here.
Jared Newell notified me that she would be absent today. Andy Noda.
Here.
Alan Plasso.
Here.
Sandra Paquette. Dr. Shaw Hughes.
Here.
Michael Toohey.
Here.
Jonathan Woolman.
Here.
We have a quorum.
Excellent. I'll seek the approval of the draft meeting minutes of October 8th, 2025 as a retirement board meeting.
So moved.
Second, any comments or edits?
I just wasn't here, so I'm not gonna vote.
Okay, Romer's
Right, I'll be abstaining too.
two,
Well, two, so
three, four. All right.
there were three of them, who's the fourth? Mom?
Tui,
Mike.
Dr. South,
Thank you.
all these. All right, all in favor, vote aye.
Aye.
Any nays? Ooh. Thank you. We will move on to the executive director report. Welcome, first meeting.
Okay, thank you. My report will be very brief. I look forward to revisiting in the coming year. Any requests from board members, if you have content for this agenda item going forward. Note, the new executive director, myself, has started in this role since the last meeting of the board. I'd like to thank all of you for giving me this opportunity. I'd like to thank the previous executive director for leaving a dedicated and talented staff. And I'd especially like to thank Heidi and Roxanne for the guidance and effort to make sure that we have this transition run as smoothly as possible for the board, for the retirement system, and myself. Treasurer, that concludes my report for the day.
Thank you. I'll also note that Sandra Paquette has arrived. All right, we will now move it to the administrative decisions. I'll turn it over to our attorney, Michael P. Roberts.
Thank you, Treasurer. Good morning, board members. It's good to be with you. The next item on the agenda is an administrative hearing in the matter of Donna Nesselbush versus the retirement system. Council and Judge Nesselbush, if you want to come up, you can. So, board members, this case is before you for consideration of a recommendation of hearing officer Charles Cucciani in connection with an administrative appeal by former Pawtucket Municipal Court Judge Donna Nesselbush. The dispute, which I will outline for you in more detail in a few moments, involves Judge Nesselbush's challenge to the administrative decision of the former executive director denying her membership in the retirement system based on a finding that she did not work in excess of 20 hours per week on a regular basis during the time that she was a municipal court judge. As a quick reminder to those of you that have not sat in on or adjudicated an administrative hearing before, or for some of you who may have never done it, this is a procedure that is established by the retirement system by regulation to resolve administrative challenges other than those relating to disability claims. Once the executive director makes a decision in a non-disability related matter, if a member is dissatisfied with that administrative determination, he or she has the right to challenge that. It first goes to one of a rotating panel of administrative hearing officers who hears the case, listens to the evidence, and makes a recommendation to the retirement board, which is why we're here. Then, once the hearing officer has conducted the hearing, in most cases, he or she prepares a written decision and it comes to the board. At the board level, the parties to that administrative proceeding each have the right to appear and make oral arguments to the retirement board. By regulation, it is not an opportunity to present new factual material to the board. The board owes deference to the hearing officer on factual determinations and questions of credibility. And this board, by regulation, will not overturn those decisions with regard to findings of fact or credibility unless they are found to be clearly wrong. The parties also have the right to submit additional briefs to the retirement board. In this case, no additional briefs were submitted, so the entire record is in convene, and the matter is properly before you today for adjudication. So with that background, I'll give you an overview of the specific facts and travel of this case that brings it here today. Judge Nesselbush was appointed an associate judge in 2004 and chief judge in 2012 of the Pawtucket Municipal Traffic Court and the Pawtucket Housing Court. She applied for membership in MERS in 2006, and she contributed to the system during the entirety of her service as a municipal court judge, retiring in 2024. In August of 2022, after receiving information from the city's human resources director that Judge Nesselbush did not work 20 or more hours per week as a municipal court judge, Executive Director Karpinski at the time notified her that she was not eligible for membership in MERS and that her contributions would be refunded to her. Judge Nesselbush sought to appeal that decision, providing a purported job description that she had prepared, indicating that the position was in fact a 20-hour per week position. She provided that to the executive director. The executive director wrote back, informing Judge Nesselbush that any revised job description would have to be officially promulgated and verified by the city in order to be accepted as evidence of the actual work hours performed. In May of 2023, Judge Nesselbush's attorney provided Executive Director Karpinski with a letter from City Council President Terrence Mercer indicating his belief that the municipal court judges were in fact pension eligible, and indicating that his belief, that belief was also true of quote unquote everyone involved. This is a letter from Terrence Mercer to the executive director provided by Judge Nesselbush's attorney. On July 3rd of 2023, Mr. Karpinski wrote to Judge Nesselbush's counsel, indicating that based on that letter from Council President Mercer and a similar one from former Council President Moran, the system was interpreting those communications to mean that council members were confirming that the municipal court judges in fact worked a minimum of 20 hours per week, 52 weeks a year. On October 11th of 2023, a few months later, Attorney Vincent Regasta, who identified himself as representing the city as outside labor and employment counsel to the city, wrote to Mr. Karpinski asking about the status of Judge Nesselbush's appeal. On November 8th of 2023, Executive Director Karpinski wrote to Council President Mercer seeking clarification on 2 points. One, does the City Council determine the work conditions and duties of municipal court judges? And 2, if so, does the council as a whole certify the accuracy of the information in the job description that Judge Nesselbush had provided? Council President Mercer wrote back on November 17th of 2023, stating that the City Council does not determine the hours worked of the municipal court judges, and he suggested that Executive Director Karpinski communicate further with the personnel director for the city if he had additional questions. And 2, that the City Council did not, in fact, certify the accuracy of the information contained in the job description that Judge Nesselbush had prepared. Importantly, on February 20th of 2024, the system received an email communication from Attorney Regasta, again identifying himself as counsel to the city, pointing out that there is no reliable or credible evidence to support the notion that the municipal court judges work 20 or more hours per week. On March 11th of 2024, the executive director again wrote to Judge Nesselbush, indicating that based on the objective evidence received from the city, he had determined that she did not in fact work 20 or more hours per week and as a municipal court judge, and that she was therefore ineligible for membership in MERS. The matter was then assigned to hearing officer Kutsiani, and an evidentiary hearing was conducted on October 30th, 2024. Executive Director Karpinski testified at some length, and Judge Nesselbush testified at length. On November 14th of 2024, before the hearing officer had rendered a decision on the case, Mr. Ragazza sent an email to the hearing officer, again identifying himself as counsel to the city, and requested an opportunity on the city's behalf to submit a brief memorandum of law for the hearing officer's consideration. On December 29th of 2024, the hearing officer issued an interim decision denying the city's request to submit a post-hearing memorandum. The hearing officer concluded that Attorney Ragazza represented the mayor of Pawtucket, the executive branch, and not the legislative or judicial branches of the city, and based upon a perceived separation of powers concern, concluded that it would not be appropriate to allow Mr. Ragazza to submit a memorandum. Almost 7 months later, on July 11th, 2025, the hearing officer issued a 54-page decision overturning the executive director and recommending that Judge Nesselbush be permitted membership in MERS. That decision is what is before you today. Before I address the actual decision and the recommendation of the hearing officer, I think it's appropriate for the board to make an initial procedural determination on who gets to participate in this hearing this morning and whether or not you will hear from the city of Pawtucket. The hearing officer declined to allow Mr. Ragazza to submit a brief memorandum of law. He has indicated that he's here this morning, and he has indicated that he still wishes to make some brief remarks to the retirement board as counsel to the city. In my view, the question of who should be allowed to participate in an administrative hearing such as this ultimately turns on a question of whether or not the person or entity wishing to be heard has standing. Standing in Rhode Island is a legal concept that really turns ultimately on whether or not the party seeking to be heard can demonstrate a particularized harm. Here, I submit that there can be little dispute, but that the city of Pawtucket as a MERS unit faces a financial impact with regard to the ultimate outcome of this particular administrative hearing. Employer contributions are clearly implicated, and in my view, there could be little doubt that the city has standing in the case. I also think that it was a mistake and an error for the hearing officer to decide unilaterally that Mr. Ragazza only represents the executive branch without any citation to anything in the record as part of that interim ruling. There's no harm to any party by allowing the city of Pawtucket to make some brief remarks. And I think it would be appropriate for the board to allow them to do that. I see no prejudice to anyone in that. But I think it's appropriate because it was an interim procedural ruling for the hearing officer. I think it's appropriate that the board take up that particular issue first before we get to the actual merits of the case. In my assessment, there are really three things that the board could do with regard to the request from the city to address you. You could uphold the hearing officer on that interim procedural ruling and refuse the city's request to be heard. You could overturn the hearing officer's interim procedural ruling on that issue, allow Mr. Ragazza to make some brief remarks, and afford them whatever weight you ultimately deem appropriate. Or three, you could remand the entire case back to the hearing officer with a directive to allow that he permit the city to submit a legal memorandum. All three of those are within your discretion and your power this morning. I think it's probably number two is probably the most efficient, which would be to allow the city to make some brief remarks and then ultimately afford them whatever weight you think. Sending the whole case back down to the hearing officer while you could do it is probably an unnecessary use of resources or inefficient use of resources. But either way, depending on how that procedural issue is resolved by the board, I will then give an overview of the hearing officer's decision on the actual merits of the case. And Ms. Nesselbush and her counsel, who are here this morning, will clearly have an opportunity to address you. And depending on how you resolve the procedural question, Mr. Regasta may have an opportunity to address you at that point as well. So I leave that to the board. The treasurer, I would suggest on that narrow procedural question, it would be appropriate for the board to discuss it and or take a vote on that question. Happy to answer any questions on that.
Questions for Attorney Robinson?
Just one question. Can you repeat what you said about deference to the hearing officer?
By regulation, the retirement board owes deference to the hearing officer on findings of fact and questions of credibility. On legal issues, not so. The idea is that the hearing officer is closer to the testimony that was provided. And so that he or she hears the evidence, they take it in, they can assess the witnesses. So this board, sitting in an appellate capacity, shouldn't be second guessing the findings of the hearing officer in terms of his assessment of the credibility of the witnesses. But on legal issues, not so. Board resolves those de novo.
So we can make a motion to hear Mr. Augusta. Did you say he was here? Okay.
He is here, and the city has continued to press its request that they be permitted to be heard by the board.
So the board could make a motion to hear him before we get into, okay,
Correct.
thank you.
Pleasure of the board.
Treasurer, should there be no additional information, I'd like to move a motion to allow the city of Pawtucket to serve as a party to this matter and provide appropriate comment as they deem necessary.
I second that.
Motion by Nada, second by Murray. All in favor?
Aye.
Any nays? All right, so moved.
Okay. So turning now to the merits of the controversy. The hearing officer, as I hope you've had a chance to look at the decision, issued a very lengthy 54-page decision, largely adopting Judge Nesselbush's recitation of the hours that she worked, doing a variety of tasks on the bench and off the bench, which included such things as appearing at city functions and ceremonies, marching in parades, renovating judicial chambers, in addition to a host of things that she described in lengthy testimony that she believed were related to her official job functions as a municipal court judge. The hearing officer also put considerable, and by the way, on the question of credibility and findings of fact, he found both witnesses to be credible. He made a point that he found both Judge Nesselbush and Mr. Karpinski to be credible witnesses. So no real issue there. The hearing officer put considerable emphasis on his conclusion that the Pawtucket judiciary is a coordinate branch of city government, and that separation of powers principles prohibit the executive branch from impinging on the municipal court chief judge's power to essentially determine the operations of the courts. He concluded that the judiciary, as essentially a coordinate branch of city government, has the authority to govern all phases of the Pawtucket courts, including the drafting of a job description identifying how many hours are worked. The hearing officer also took issue with Mr. Regasta's efforts to articulate a position on behalf of the city, finding instead that he represented only the mayor and the executive branch, which he concluded have no jurisdiction over the functions of the courts. I think that finding is a bit ironic, given that the hearing officer refused to allow him to even make any remarks or submit any briefing to him, but that was in fact the finding of the hearing officer. The executive director's position in this case was pretty straightforward. Pursuant to the statute, the retirement board shall decide who are employees for purposes of pension eligibility. But in no event under the statute shall it deem as an employee someone who works less than 20 hours per week on an annual basis. This board has that power to decide who are employees within the meaning of that chapter. The system had discussions and communications with the city's HR director, who indicated that Judge Nesselbush did not in fact work more than 20 hours per week. Judge Nesselbush prepared her own job description, indicating that the position of municipal court judge was exactly 20 hours per week. But when the system sought clarification from the city council, the council president expressly stated that the council could not confirm the accuracy of the information in Judge Nesselbush's job description. MERS received a communication from an attorney indicating that he represented the city and further indicating that there was no reliable evidence to support a claim that Judge Nesselbush worked more than 20 hours per week. The judge herself pointed to numerous extrajudicial activities that she voluntarily engaged in, which are no doubt important, but the objective evidence in the assessment of Director Karpinski did not corroborate her claim that her official job duties were more than 20 hours per week. Moreover, there was concern on the executive director's part that the judge's position in this case would essentially allow municipal court judges to unilaterally write themselves into pension eligibility simply by stating that they decide their own workloads, devoid of any required corroboration by any other municipal official. The notion of separation of powers principles is, in my view, a bit of a red herring, because it is a concept that is, according to the Rhode Island Supreme Court, foreign to municipal governments. And I don't think it's a concept that, in my opinion, should affect the outcome of this case. Judge Nesselbush is a city employee. She receives a city paycheck. It would be completely appropriate for the city's HR director to make a representation to the retirement system regarding her hours worked, and for MERS to rely on the formal representations of the city in determining pension eligibility. The hearing officer's decision would essentially allow Pawtucket municipal court judges, and by extension, municipal court judges around the state, to essentially write themselves unilaterally into pension eligibility. I suggest that not only is that not the law, it would also create enormous administrative difficulties for the retirement system when attempting to verify the hours worked by these particular employees. So in my assessment, the hearing officer's recommendation to you is incorrect and misguided. And it would be my recommendation that you reject that recommendation of the hearing officer and affirm the recommendation of Executive Director Karpinski that Judge Nesselbush is not, in fact, eligible for membership in MERS. I think it is unnecessarily risky to require the retirement system to wade into intra-city conflicts between the various branches of city government. And at the end of the day, I think it's appropriate for the retirement systems administration to be able to rely on the formal representations of city officials. With that, Treasurer, that would conclude my presentation and recommendation. I think based on the board's interim vote, I think it'd be appropriate for Mr. Regasta to take a seat at the table. So Ben, you can do that if you like. And then I suggest that it would be appropriate to hear from Judge Nesselbush's counsel, who can make whatever presentation he believes appropriate on her behalf. If Judge Nesselbush intends to address the board herself, that would be okay. Again, no new evidence or testimony is allowed, but she can make argument. But we'd like to have her sworn in if we're going to do that. And when the city's, Judge Nesselbush's counsel is concluded, then Mr. Regasta would have an opportunity to address the board, and then the board can ask any questions of any of the parties, and then proceed to a vote if appropriate.
Please proceed.
Thank you. Good morning, board members. My name is Michael Garland. I am a partner with John Harwood. We have offices in Smithfield, Rhode Island, and we represent Judge Nesselbush in this matter. Again, I think, and I don't know, the sense I get is that you have not had an opportunity to review Mr. Puziani's decision, which is comprehensive, contains 40 separate findings of fact, accurately recites the law regarding these types of matters. And hearing from Attorney Robinson, what I feel is that my client is she's a victim of a flawed system. There's no evidence, there's no denying that she contributed or made contributions to the pension system along with the city of Pawtucket for almost 20 years in this particular matter. She was chief judge of the municipal court with all kinds of duties incumbent with that. The decision by Attorney Kutsiani makes reference to the fact that as time went on and after she became chief judge, the job responsibilities or her work responsibilities in that position actually increased based on changes of the law. For example, on page 29, the court becomes increasingly busy as tickets were issued in the thousands and that sort of matter. And so the job on its face was a 20-hour position. And let's be clear here that Judge Nesselbush was requested to provide a job description because none existed before. And the fact that Human Resources claims they couldn't track her hours, well, that it should be on them and it should not be to penalize my client. I don't think there's any dispute that she provided good service, excellent service to the city of Pawtucket. First as an associate judge and as chief judge of municipal court. And what I hear from Attorney Robinson is that a concern or a fear that her case will set a precedent for other municipal court judges in the state of Rhode Island, and that is inherently unfair to my client. She did the work, she worked more than 20 hours. Mr. Kutsiani found that she was credible in giving testimony about the amount of time she worked and did the job. And so she's being punished because of a flaw within the system itself. With regard to Mr. Augusta and his participation in this matter, he does not represent the city of Pawtucket. As Mr. Kutsiani indicated, he represented the mayor's office. And without getting into politics, and he made a very clear distinction and did not want to go into that area. With all due respect, she was appointed by the city council. She was reappointed as time went on because she did the job and did it well. And I fear and I feel that the objection by the mayor's office, because it's not the city, it's the mayor's office, is based on political considerations and not based on her service to the city of Pawtucket as a judge for almost 20 years. There was no objection filed, and perhaps there's a question of standing, but Attorney Augusta could have filed an objection as mandated by your procedural rules. He did not do so. I think there is a sound basis for Mr. Kutsiani not allowing him to submit a brief while this matter was pending. And the fact of the matter is that the basis for the denial of her pension benefits was thinly based on a website that was outdated, had not been updated. There was never any interviewing of my client by the city. There was never really any investigation of the city, and there was reliance by the retirement board, primarily on Attorney Augusta's submissions that led to the denial of her benefits or her request or application for pension benefits. I think, in all honesty, it would be a travesty for the retirement board to reverse the decision of the hearing officer as it's accorded great deference. He found the credibility of both witnesses, but also made specific findings of fact that cannot be challenged by the retirement board. I know my client wishes to address the board, and I will leave it at that. Thank you.
All right, Attorney.
We have, where's our star?
Yes,
Okay.
I'll swear, yeah. Raise your right hand, please. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I absolutely do, so help me God. Ladies and gentlemen of the retirement board, as the petitioner myself, as the only one personally and forever affected by your vote here today, it's hard for me to know whether I should address you personally or just allow my attorney to speak for me. But ladies and gentlemen, they say that the truth will set you free, so here's my truth. A couple things I want to address about Mr. Robinson's legal averments in this case. He indicated that I tried to write my own job description. When I spoke collegially with Frank Karpinski, he understood everything I was saying and said, Donna, is there a job description? I said, Mr. Karpinski, there's never been a job description. Yet every judge who ever came before me in the city of Pawtucket was enrolled in the MERS. Those who served long enough to vest received their pensions. There's never been a job description. It's never been questioned what we do or how many hours we work or whether we work the requisite 20 hours. So he said, Donna, why don't you get a job description? So I dutifully wrote an email to the mayor of the city of Pawtucket saying that I had been in contact with Frank Karpinski. And he suggested that I write or come up with a job description. So I wrote to the mayor and his chief of staff, who is a great man, Dylan Salazzo, as well as the city solicitor of the city of Pawtucket, Frank Milos, another great man and friend. Dear Dylan and Frank, I am writing to you in your official capacities as Director of Administration and City Solicitor, respectively. Thank you both for speaking with me about this issue. As we are council appointees, not appointees by the mayor's office, I have also spoken to Councilor Mercer, and I believe he has discussed this briefly with the mayor. As you requested, because I spoke with Dylan and Frank, and they too said, get us a job description, Donna. As you requested, attached is a judicial protocol or job description that I drafted based on my experience as having served both as the associate judge and then the chief judge of our city for over 18 years. The document outlines the responsibilities and duties of the municipal traffic and housing court judges. Please let me know if you have any questions. After reviewing and finalizing this document and conferring with the city council if that is necessary or warranted, I respectfully request that the appropriate person in city government draft a cover letter or other appropriate document to Frank Karpinski from the employee retirement system, assenting to and enclosing the final version of the judicial job description. Thank you for your kind attention to this matter. So I reached out to the mayor, the city council, Terry Mercer, the city solicitor, and said, look, the executive director is requiring a job description, so can we get one together? I'm a city employee, don't I deserve a job description? Now, ladies and gentlemen, if you work at wherever you work, if you were gonna get a job description for yourself, wouldn't you be the first person that wrote down what you did, subject to the higher authorities like the mayor and the city council or whoever your bosses would be? I did exactly what was asked of me. So what happened? When I asked the mayor for his involvement, he hired Vin Regasta. Vin Regasta wrote an entire memorandum of law, which is before you in this document. And if you'd like to see it and you give me a moment, I will find it and I will quote from Vin Regasta, who in no uncertain terms echoed what Frank Milos, the city solicitor, said to the mayor, which is that, Mayor, you have absolutely no authority over the judges. You have no authority or ability to authorize or confirm a job description. That's only with the city council. What did I do when Vin Regasta wrote that in black and white in the materials that are before you? And if you'd like to read it, I will point you to it and we'll make a copy and every single one of you can read the memo from Vin Regasta telling the mayor that he has no authority to even be involved in the process of writing a job description for the judges. You know, there are different things. The mayors get certain appointments in city government and state government. And the city councilors get their own appointments and things. This particular one, the judiciary, coming from the General Assembly on down, the authority rests entirely with the city council, not with the mayor. So what did somebody here at the retirement system, I'm sure a person who was trying to do their job, they contacted the city's personnel director. Now, she worked for a short stint at the city of Pawtucket. I've never met her. She never stepped foot in my courtroom. What did she do? And I can tell by the letter that Frank Karpinski issued, she simply quoted from the website of the city of Pawtucket as to the hours that the court was open to the public. Now, anybody who thinks that judges only work the hours that they're open to the public doesn't know what judges really do. We have to review cases, we have to write decisions, we have to research the law. We have no staff in the municipal courts. And by the way, the Pawtucket Municipal Court is an entirely different animal from all the other municipal courts in the state. Every municipal court is different. The city of Pawtucket tried to equate me with a Tiverton judge where they meet like maybe, I don't know, once a month, once every 2 months. The Pawtucket Municipal Courts meet 3 times per week, every week. We have no staff. At some point, the mayor needed my clerk's position. And I said, you know what, we'll take it on. We'll work with the city. You know, we don't need a clerk to do our research. We'll do it for ourselves. It's all part of the 20 hours we work. And so the job description was promulgated. And I take entire issue with, I don't know how Mr. Robinson could tell you that the city councilors said that they couldn't confirm my job description. Let me quote from the president of the Pawtucket City Council. This was the previous president, David Moran. And this is, you know, right in the time frame after this whole issue came to light in December 8th of 2022. And he says, I can confirm that all of the information you provided, because of course, when Vin Regasta told the mayor he had no authority, I sent my job description to the city council. I can confirm that all the information you provided appears true and accurate to the best of my knowledge in terms with the role of the judiciary in our city government, the duties and responsibilities of our judge, who most certainly are considered city employees, as you have outlined them in the job description, appear reasonable and accurate to the best of my knowledge. Moreover, I fully understand that you and Judge Gannon's work to run the judiciary and effectuate a number of special projects means that your position as city judges for the city involves more than the hours you simply work on the bench. Then, when the council president changed and Terry Mercer came on board as the new president, he wrote another letter basically saying that he confirmed everything that Council President Moran had already said in his thing. What does it mean when you say that you confirm everything he said and that he helped to write the letter and that he agrees with its contents, intents, and purposes? It means that he too received the job description and says that it is accurate to the best of his knowledge and ability. Now, again, Mr. Robinson is trying to do smoke and mirrors for all of you. When he says that the city council can't confirm my job description, what he means is that the city council said, look, we appoint the judges. We stay out of the judiciary. The judiciary then runs itself. Now, if I have the power to hold people in contempt, if I have the power to say that you're guilty of a traffic violation and that you're not, you have a housing violation and you don't, if I have all of that authority, including the authority to jail people, I might add, do I not even have authority to draft my own job description? I mean, that is ridiculous. Now, the fact that Sarah Miranda, the only evidence in this case where she reads from the Pawtucket website, never has met me, never spoke with me, never asked me how many hours I worked, or, by the way, Judge, do you do anything outside of the hours you sit on the bench? If you just take my case as a microcosm and you look at the number of hours that we were in this room, sort of open to the public before hearing Officer Gianni and here today, it's a fraction. It's not 1/10 of the hours that all of the lawyers have participated in this case. Just to give you some idea of the additional work that goes into cases besides the mere hours that a judge sits on the bench. I mean, that is just, it's insulting to anybody's intelligence that, you know, how our courts work. Judges obviously do a lot more work than the hours that they are on the bench. And I will tell you that for the 20 years that I was the chief judge of the city of Pawtucket and the municipal judge, I could never travel out of the state without coordinating my travel with the other judge, because the judge has to be on duty at all times. By ordinance, which is law, by law, the Pawtucket municipal courts are in session at all times. If the Pawtucket municipal courts are in session at all times, because we have emergencies, there are fires, there are chemical explosions, we have to evacuate buildings. I mean, there's things that happen at all hours of the day and night. There have been countless times that the inspectors have showed up to my own law office saying, Judge, we need an emergency order. Come on up, explain the situation to me. Let's go over it. Let me check a few things, you know, let me do a little research, make sure we're on solid legal ground so that the city is not exposed to liability. let me get one of my associates to do some work so we can figure this out here. Okay, great, I'll sign or I won't sign a court order. That is just a small fraction of all the other work that goes into being a judge besides the hours of operation that we are open to the public. Now, add to that, that years ago, the city of Pawtucket went to camera enforcement. We had to add an entire docket, 3 separate, it was 4, 5, and 6 p.m. An entire extra docket on Thursday evenings dedicated to thousands. And when I tell you how many tickets these cameras issue, they are in the thousands. We had to come up with new procedures. We had to come up with, again, I'm not going to go into that because additional evidence should not be taken today. And that's why you should rely on what the hearing officer wrote in 54 pages, because he researched everything. He did a very thorough job. He took time to go through all of the evidence, something that is obviously beyond the purview, of what all of you can do here this morning. But what I also want to say is that, I have been a practicing attorney and a practicing attorney for 30 years, over 30 years, and a municipal judge for 20 years. And I can tell you that this is the craziest case I have ever seen. I'm in the pension system and vested in the MERS for 18 years. And suddenly I'm kicked out of the MERS pension program. Then fast forward, I get reinstated. July 3rd, Mr. Robinson said, Frank Karpinski reviews everything that we all just talked about and realizes that he had not really gotten a clear sense of what was going on. So he reinstates me, puts me back into the pension program. Then fast forward several months later, I get kicked out of the pension program again. Now, any normal person like yourselves, any normal attorney like ourselves, would struggle to understand this back and forth decision making. Is our retirement system really that fickle, or is there something else going on here? Ladies and gentlemen, there most certainly is something else going on here. You may have read in the materials submitted to you that every judge who came before me was enrolled in the municipal MERS retirement system because the city of Pawtucket long has known that their judges work the requisite 20 hours. Those judges were all enrolled, and those who, worked the requisite number of years to vest, they received their pension credits. Judge Keogh, Judge Mutter, the judges McBurney's, or, Judge Noonan, they're all seeking their pension credits because they all came before me. They all were enrolled. They all are seeking their pension credits. Those who actually retired got their pension credits. You may have also read in the materials, and as Mr. Robinson said, for 20 years, the city and I made all requisite pension payments so that this pension is fully funded. And you may have read in the materials, as I previously quoted, that both the current city council president of the city of Pawtucket and the former president support my pension eligibility. So again, what is going on here? Essentially, this is a power struggle between the branches of government in the city of Pawtucket, where the city council, the legislative branch, and the judges, the judicial branch, are in favor of my pension, but the mayor, the executive branch, is opposed to it. Fortunately, as the hearing officer made crystal clear in his decision, based on the facts and the law, and based on Mr. Vergasta's own memorandum and his own words, the mayor has absolutely no statutory authority over the judges or over my pension. So you may be asking yourself, why would Pawtucket's mayor single out Judge Nesselbush and try to torpedo my pension eligibility? You see, give me a moment. The truth is that this case has nothing to do with me and everything to do with a well-known, well-publicized, and long-standing war in the city of Pawtucket between two men, Mayor Don Grevian and my previous associate judge, Judge Jack Gannon. You see, Mayor Grevian and Judge Gannon were once great friends. Judge Gannon, before he was a judge, served as the mayor's #1 guy, director of administration, and the chief of staff. But a war began when, for reasons I will not go into today, the mayor fired Jack Gannon's son, who was a probationary firefighter. The men became arch enemies, and World War III ensued in the city of Pawtucket. Add to that the fact that there were multiple lawsuits back and forth between the two men, and that the city council chose to appoint Jack Gannon, the mayor's arch enemy, as my associate judge years ago, probably 10 years ago. Add all of that together, and you now have a cauldron of power struggles within the city of Pawtucket. Make no mistake, by law, the city council has exclusive authority to appoint the judges and to, regulate the judges. And the mayor has, again, statutorily, in Vin Regasta and Frank Milos, the city solicitor, two lawyers told the mayor that by law, the mayor's office has no statutory authority over the appointment of the judges, over the judges' work hours or hours of operation, or over their pension eligibility. Nonetheless, this power struggle ensued, and the mayor frequently tried to usurp the authority of the city council to appoint the judges, and that's within their purview. As recently, skirmishes have broken out between the mayor and the city council as recently as last year, when I finally went, because my retirement issue was finally resolved and I decided to retire after 20 years. Another skirmish erupted because the city council, as a further snub to the mayor, decided, and it is their prerogative, to elevate Jack Gannon to take over my position and become the new chief judge of the city of Pawtucket. In fact, the evening before that vote was to take place, when the city council had told the mayor, sorry, you have no authority here, we're going to do what we want, which is to elevate Jack Gannon, Vin Regasta fires off a rocket over to Frank Karpinski, trying to throw a whole bunch of mud against the wall, repetitive, duplicative things that had been said in this case time and time again and before, that made no sense neither to Frank Karpinski, who reinstated me, or anyone else. Less than a month later, after this rocket email on the evening before the city council snubs the mayor, I get kicked out of the pension again. Now I'm actually in retirement. Now, I can understand that the mayor was and is not happy that the city council appointed his arch enemy to be the city's chief judge. But in my opinion, the mayor's response, hiring Vin Regasta to come back in and battle my pension, it's just an over-the-top abuse of power that goes against everything I have stood for my entire career as a lawyer and as a judge. It's frankly infuriating to me. As the chief judge of the city, I of course knew about all of these power struggles, but I tried to fashion myself as Geneva. I was a neutral one. I got along well with everyone, I thought. Got along well with the mayor, got along well with the city council, and got along well with my associate judge. Again, it wasn't my job to pick him. The city council gave Judge Gannon to me, and to his credit, he was a great associate judge, and I assume he was being a great chief judge. Unfortunately, despite my attempt at neutrality, I instead became collateral damage in a war in which I never even fought. The details of this war and the power struggles are outlined in all of these materials, including all of the newspaper articles, all of the TV coverage. You can print it offline now. It's all there in black and white. But sadly, and it's very sad to me, it appears that Mayor Grebian has taken some page out of a Trump handbook, trying to abuse his power by targeting his political adversaries, Jack Gannon and those on the city council who chose not to go with the mayor's choice for who would be the next chief judge, but by elevating Jack Gannon, as he should have been, based on his great service to the city. All of the ways in which the mayor has been trying for 3 years to even the score. All of his malfeasance is well documented in the materials that we submitted to the hearing officer. You see, without understanding the political context, this war between the city council and the mayor's office, in which I am just, again, a victim of collateral damage. Remember, when all of you are thinking about this, every judge who came before me was enrolled in the MERS pension system. The city paid pension contributions for all of them and for all of us for all those years. Do you think they just made a mistake and said, oops? It makes no sense without understanding the political context of this controversy. As I've said, otherwise, reasonable people like yourselves, if you didn't understand that, would be scratching your heads, wondering why, if all the judges who came before me had no problem, if the city for 20 years funded the position, and if I testified and my testimony was found supported, corroborated, persuasive, I mean, the hearing officer could not have accepted my credibility any more than he did in the 54-page decision that he wrote. So why would my pension eligibility suddenly be questioned? I'm here this morning to tell you that unequivocally, it is being questioned because of political power struggles in the city of Pawtucket and political animosity. Fortunately, notwithstanding this political animosity, the facts and the law are totally on my side, which is why the hearing officer wrote 54 pages explaining the reasons why I am pension eligible, explaining all of the duties that I have. And again, very disingenuous of Mr. Robinson to cite certain things like me going to political ceremonies. What he's not mentioning is also my testimony about researching cases, writing decisions, speaking with countless other people in City Hall. I have to work with the police chiefs. I have to talk about security in the court system. I have to talk about not only keeping the judges secure and safe, but also the general public secure and safe. When the city wants to do camera enforcement, I have to make sure that the notices that are sent out to the motorists are constitutionally sound and valid and can withstand scrutiny if any of those cases go up on appeal to other courts. There's so much more that goes into the job of being a municipal judge. And again, the Pawtucket municipal courts are very busy. Make no mistake, we are not here saying that every municipal judge gets to come into the MERS. We're simply saying that, for instance, all of the Providence judges, another very busy court, are certainly all in their pension system. And again, Pawtucket judges have always been in the pension system. Ladies and gentlemen of this committee, this case is not about money for me or about my pension eligibility. It's about an attempted abuse of power by the mayor who has singled out my pension, whose value, by the way, is approximately $7,000 a year. $7,000 a year from a $12 billion pension fund that has 65,000 members. None of it makes any sense, ladies and gentlemen, unless you take into consideration the political context, which I unfortunately, I've tried to avoid going into that level of detail, but when I am here and seeing that Mr. Regasta, again, with all due respect to my brother and colleague, he is a hired gun by the mayor, wasting taxpayer money to continue to fight this fight when it has nothing to do with me and everything to do with his battle against another person in city government. Ladies and gentlemen, you have the power to right this wrong. I have explained to you why this case is here, and I have explained to you why I'm here. I'm here because of this abuse of power by the mayor is contrary to law, it's contrary to honor, and it's contrary to everything I stand for as a lawyer and a judge. That's why I urge you to not be distracted by the mayor's own hired gun, who has been throwing mud against the wall in this case for the entire 3 years this case has been percolating. Instead, see through to the facts of what is really going on here and do the right thing. And I urge you to affirm my pension eligibility, 53 pages of which you have right before you as to why a neutral hearing officer that works for this employee's retirement system found in my favor. Thank you very much, ladies.
Thank you. Before we move on to Attorney Augusta, I'm just gonna do a 1-minute break, bathroom break. So if anyone needs to use the restroom, please do so now.
But we don't want to get him in trouble.
Yeah.
He's there. Yeah, I don't.
No, no, you're not. All right,
No, what you said last night was perfect.
Yeah, so that was perfect. Yeah, no, he's.
all right, we will resume, turn it back to Attorney Roberts.
Thank you, Treasurer. There was a lot there, and I'll only make just a couple of very quick responses to the 3 points. Yes, contributions were made during the entirety of Judge Nesselbush's service to the city. That in and of itself is not unusual. The system relies on the employer to make contributions. They come in, they don't get reconciled necessarily or audited until the member goes to retire, in which time, in this case, the $16,000 annual salary popped up as a flag against the hours worked. So just the fact, while regrettable, the contributions were made during that period, it's not unusual necessarily that it wouldn't be looked at by the system until the member goes to retire. There was a lot there. I would just caution board members again that this is not an opportunity to present new factual material or new evidence. So to the extent you can try to filter that out as you're evaluating what you heard this morning, I would suggest that that's the appropriate course of action. And then the last thing I would point out is with regard to the city council, there is a letter dated November 17th of 2023 that I referred to in my opening remarks. It was respondents exhibit number 12 to the transcript. And I think it's a significant piece of material in the case. It was a letter to Director Karpinski from the council president in response to 2 specific questions that were being asked by the executive director. Does the Pawtucket City Council determine the conditions and duties of employment for the Pawtucket Municipal Court judges? The response, short answer is no, period. Suggested that they talk to the city's personnel director. Second question, if the Pawtucket City Council does have the authority to determine the conditions of employment for Judge Nesselbush, does the council as a whole, not just Council President Mercer, certify the accuracy of the information contained in the job description prepared by Judge Nesselbush? Again, the response to the question was no. The city council does not determine the working conditions and does not establish job descriptions for the judges. The objective evidence that the system was relying upon was largely this. So with that, Treasurer, I think it'd be appropriate to allow Mr. Regasta to make some remarks, and at the conclusion of which members of the board may have questions.
Please.
Mr. Chairman, just one quick thing. This is not new evidence. This is already in the record. And this is, and I'm going to just read one sentence, the very first sentence of a memorandum of law written by my brother attorney, Ben Regasta, on December 8th, 2022. And it says, for the reasons that follow, and given the facts as known and presented to us, it is our professional opinion that the mayor of the city of Pawtucket does not have operational authority over the city's municipal court. Rather, that authority lies with the city council by virtue of a legislative grant from the General Assembly. So if the mayor's office has no authority over the judges, then anything that Sarah Miranda, who works for the mayor's office as part of the executive branch, anything that she would have to say was found by the hearing officer to have no legal merit. Because again, the city council has the authority and they delegated it to the judges. When Mr. Robinson cites that letter and he says that the city council doesn't, they don't supervise us. We are a co-equal branch of government. It would be ludicrous in any state court system or any system of government. The judges are the judges. Once you appoint them, they of course, they're not subservient to the city council or to the legislature as to, oh, I worked 4 hours today. We are salaried employees. There are no records like that required because we are salaried employees. So now that I have read to you what Mr. Regasta said in black and white to the mayor, now he's going to come and talk, with all due respect to my brother, you'll hear what he has to say out of the other side of his
Please proceed.
mouth. Nothing personal to
Nothing personal.
Uh,
I've been called a hired gun, but as you can see, I'm not a big gun. You know, I'm gonna be very brief, and let me underscore the word brief because, your counsel, has done assiduous work in writing a memoranda both after the hearing before Mr. Kutsiani, and a reply memo. And what I would encourage you to do is to read those memos and read them very closely, because they address not only the evidence that was put before the hearing officer, but more importantly, the legal issue. I commend my brothers, my sister for their eloquence, and your passion. But let me be blunt about this. This is a pension grab. Rhode Island has a rather sordid reputation for employees seeking pensions. And although the city does not administer the pension, the city partners like any other employer in vetting eligibility. And the city must be honest, and the city must provide whatever evidence it has in that vetting process. There's no evidence that was corroborated that the judge works 20+ hours weekly, each and every week. Let's also be blunt with one another. This is Rhode Island. There are many municipal court judges. By the way, I'm the son of a state court judge who sat on the bench for over 30 years. I'm the brother of a municipal court judge. I have a sense of what they do. And we all know, let's not delude ourselves, these are political plums. No question, with all due respect, did she discharge her duties competently and efficiently and effectively. But the notion that she worked 20+ hours per week, well, I find that insulting to the intelligence of anyone. That's just not the case. That's not the case, and it's not the case each and every week. You know, the employees that are eligible for these pensions, many of them that are unionized, many of them work 40 hours per week, 35 hours per week, many of them work overtime. They meet the criteria for eligibility. This is not a cherry on top of the sundae that was served to her when she was appointed. And again, I'm not criticizing the work that she did, the quality, her dedication. She's a highly respected attorney, and she did wonderful work on that court. But let me tell you what she didn't say about my opinion, and you're gonna get my opinion. And yes, she's correct. I'm correct. My associate's correct in the opinion we gave about the operational control of the court. But she neglected to tell you what I put in the footnote of that opinion. The question whether the sitting municipal court judges have actually devoted 20 business hours per week in the past, that's a factual question beyond the scope of this analysis. Based on the information we have been provided, it appears that the City Human Resources Office has already informed ERSRI that there is no evidence that municipal court judges work 20 hours per week. What do you have in front of you? What did the hearing officer have in front of him when he made his decision? He had what I call take my word for it evidence. I work 20+ hours per week. And by the way, it's not just my time on the bench. And I agree. I'm sure she did work and rendered services and did analysis. But if any of you are members of the bar, I would suspect you would agree with me that we're not talking about deep, complicated jurisprudence in the municipal court. That's just not the case. Every now and then, complicated issues arise that have to be addressed, and I'm sure the judge has done some research. But the notion that she did 20+ hours per week, each and every day, it's just not believable. It wouldn't be believable by any member of the bar. And I suggest it wouldn't be and shouldn't be believable by you. The job description, well, she wrote her own job description. It was never authenticated. It was never corroborated by anybody on the city council, and according to the city solicitor, and I know Mr. Robinson has addressed this in his memoranda. There's no evidence that they promulgated that and said, yes, this is the official job description. She writes a job description and says, I work 20+ hours per week. Now, I'm not quibbling with what she has enumerated as her duties and responsibilities. But again, if she says, I work 20 hours per week, there are no contemporaneous records of her doing so, not a shred of evidence. And nothing was corroborated other than her own self-serving testimony. So at the end of the day, I think the hearing officer got it wrong. And he got it wrong because he accepted everything that was put in front of him, which was totally self-serving to get beyond the eligibility threshold. You know, if someone says I rendered services of X number of hours, most people, whether it's a lawyer, an accountant, or anyone in a profession, service profession, one would ask for some detail of that. One would ask for some corroboration of that. You just don't pay a bill blindly without knowing what these services were rendered. Here you have someone who comes in and says, I work 20+ hours per week, each and every week. And by the way, she's an extremely successful partner in a law firm. I think she's a founding partner, if what I read online is correct. She manages a firm that's sizable. And again, anyone who's practiced law in a big firm, a mid-sized firm, even a small firm, it takes a lot of time each week to practice law in that capacity. I just don't understand how somebody could do 20+ hours per week and run that law firm. It just doesn't make sense to me. Doesn't make sense, and it should make sense to you. Again, all I will say to you is please read your counsel's memoranda. It's well done. It summarizes the evidence and the legal arguments in a way that will guide you in making a proper decision. And that decision ought to be the pension is denied.
I have nothing else further.
Mr. Chairman, I have just one quick thing to say. He's absolutely right. Nobody should just believe a bare assertion that somebody, did something. The 8-hour hearing that was before hearing officer Gianni, this amount right here of this brief that was submitted to the hearing officer has to do with legal issues and legal argument. Here are hundreds of pages, probably close to 400 pages. Thank God that we all do most of our work by emails these days, because I was able to, by doing random searches, Tucket City Government, produce 400 pages of contemporaneous emails discussing cases, asking questions, dealing with issues about the camera tickets, about security with the court. So as my brother here asks you to look at Mr. Robinson's brief in this matter, I urge you to look at the actual evidence. You will see 400 pages of the various types of things that I worked on as a municipal judge for 20 years. And again, this is ridiculous. All of the Pawtucket judges, what are you going to do? If I'm not found to work 20 hours a week after I submit hundreds of pages, are you gonna go back and remove the pensions from all of those pension credits that have already been paid? I mean, the only thing that makes sense here, ladies and gentlemen, is to provide the pension credits that I was promised, that I worked for, that I proved in an 8-hour hearing before a hearing officer with hundreds of pages of contemporaneous evidence, the work that I did, not to mention, Mr. Gianni was the only one judging credibility. He is the only one with the legal authority to do that because he sat with me for 8 hours and he found time and time again in his 54-page decision that my testimony regarding all of the things that I did for the city of Pawtucket were supported, reliable, corroborated by actual evidence, and that he found me to be a credible witness. So
Appreciate the comments. I'm now gonna shift it over to the board for any comments or questions. Please.
I have several questions. So the position, when you accepted it, had no written job description.
Correct.
And all prior judges had the same position, no written job description. And all judges prior to you are receiving their pension if they qualified with the proper time serving in that position.
Yes,
Is
sir.
that correct? Is there any argument from the city against any of that, those facts?
No, I mean, I think I indicated that the job description had not been promulgated by the city council. There was no.
There was no job description per se that existed.
That's correct. But there are charter-based requirements for the duties and
So
responsibilities.
does either party disagree that the town council, the city council could have endorsed the job description, voted on it and approved it? We agree that that's within their authority?
They wrote letters endorsing it.
No, well, the council president wrote a letter.
Yes,
But but he could have brought that job description before the full council for codification.
I think it's not, I mean,
I'm just, it's a yes or no.
I don't think it's that simple because I think,
It's a yes or no. I think it is that simple.
I think it involves a legal interpretation of separation of powers.
I-
mean, it would be, so I can't answer that question. sir.
I believe the council could, even if it violated separation of powers, they could have brought it before the council and they could have codified it. I'm going to caution the city of Pawtucket today that if there isn't a job description for the current judge, there should be.
oh, there is, it's been
It's
in
had-
effect
It's been in effect and codified?
since I wrote it, yes. I mean, I am the chief judge.
No, I understand. I have no.
Yeah.
I have no argument against you having the ability to write your own job description. But I think the appointing authority should have approved it.
I don't think the state legislature
So-
approves any job descriptions of the state judges.
We're not
so
talking
that
about
would
the
be-
state legislature, we're talking about.
That would be on.
We're talking about local appointed officials, so I'm on both sides of it. In certain communities, there are ordinances that say appointed officials such as judges don't get pensions, and there may be ordinances that say they do get pensions. I would caution the city of Pawtucket to actually codify this process somehow. Okay, so, you know, and one thing that you said, Mr. Regosta, was that no member of the bar would accept, you know, that explanation. However, I believe that the hearing officer is a member of the bar.
Well,
And he did accept it.
he may be very gullible.
I'm just saying, you know. No, I'm just, well, that's, Right. we can object to many statements that were made throughout all presentations, but this is a kind of informal, formal hearing, so I accept that as humor.
Well,
That's fine.
sometimes jurors don't get things right. Judges don't
I
get things right. And here it is.
even make mistakes.
We all do.
So,
Well,
those are all my questions for now. I may have some more.
Good. Moving on to Bill Murray, then I'll go to Sandra.
I just wanted, Mr. Grasta, I just want to clear up something. The mayor has nothing to do with this appointment, overseeing anything, is that correct?
yeah, and that's a very interesting question. And generally speaking, I would say yes, but there's a caveat, and Judge Nesselbush conceded that she is an employee of the city in a judicial capacity, or she had been. And obviously, the executive branch of government processes payroll, maintains personnel records, and so forth. So the mayor doesn't exercise, nor does anybody in that branch of municipal government, to the extent we're even going to get into the notion of separation of powers within a municipality, which, by the way, is not applicable based on a Rhode Island Supreme Court decision. But the mayor doesn't, he doesn't monitor day-to-day activities of the judges.
So that clears the air as a political battle, which was mentioned.
Donald Trump and Donald Grevian had nothing to do with this case.
Oh, is Donald Trump involved in this?
Well, I think She referenced abuse.
I heard that, yeah, I'm just being sarcastic right now, but. Okay, thank you.
Sarah,
I'm
Walmart, do you have a
trying
question?
to,
You have a question too after?
yeah,
Okay,
I'm trying to look at this very objectively because it is, as we all will agree, a very complicated issue. But the things that stand out in my mind, and I'm trying again to eliminate personalities and just looked at the evidence we're being presented with is number one, I think it's been established that the judge was asked to write her job description. It almost appears that in some instances we are denigrating that job description because it was written by her, but she was asked to do that because there was not one in effect, and it obviously has been accepted because it continues to be used. The second thing that concerns me is that all of her predecessors were accepted into our pension fund. It is an item of concern to me. Why suddenly was someone not? And if truth be told, she was, and then it was withdrawn. Again, factually, that concerns me. The third thing that concerns me is the fact that we have a hearing officer. And again, you did make a denigrating remark about our hearing officer, and I don't think that's fair to him. I think this is a man who spent 8 hours listening to testimony. I think we have to accept the fact that he responded in a way professionally he felt was correct. And I don't personally feel we can just toss aside 8 hours and how many hundreds of pages of actual testimony and say, no, they don't count. That is my opinion from looking at it very objective.
May I just respond briefly, only
Please.
because I did not denigrate him. I disagree with his assessment of the evidence that was adduced in that hearing. And I think it's appropriate, perfectly appropriate to say, I don't think that there was a basis for him to be so gullible and accept self-serving evidence. And with respect to that job description, the judge had indicated that that wasn't drafted at the suggestion of anyone in city government. It was done at the suggestion, if I heard this correctly, of Mr. Kopinski.
Yes.
But the job description is not evidence per se of actual hours working. And she correctly pointed out, our legal opinion about the autonomy of the court or the operational control and jurisdiction of the city council indicated rather clearly, there's no evidence of the 20 hours, 20+ hours per week.
And why was there evidence prior to this of all of those other judges?
I can't speak to that. I don't know.
But it
And
is
for all I know, by the way, there may well have been evidence that, for example, a probate judge, they deal with much deeper, complex legal issues, whether it's will contest, testamentary capacity, guardianships. You know, probate courts have quite a bit of, shall we say, more complex legal issues than someone sitting on a housing.
But I
court.
believe the reference was made to the previous municipal court judges as
Yeah,
well.
none of my references were to that. We've had the same municipal judge.
Right,
for 30
and
years, so
This
she's-
Judge McBurney, she is the.
No, that was John McBurney. my
Oh, okay,
predecessor.
all right.
Yeah.
My apologies.
Okay.
Mr. Walmer?
Thank you, Chair. From the city's perspective, I think I've heard you say that you agree that the city pays, the executive branch pays the paycheck. Are all employees of the city enrolled in the MERS system automatically when they join? Or are some not enrolled at the beginning and like so when their paycheck, pieces in, pieces out?
I believe if they're eligible in terms of the hours worked, then they would be enrolled.
And the judge was enrolled.
Right.
Okay,
But
that's all my questions. Thank you.
Andy?
Treasurer, can I just follow, Mr. Walmer's question there? So in terms of that specifically, in my experience in municipal government, you have, as an employee, not all employees are enrolled in the state's pension or in MERS. And you have to work at least 20 hours, but the functional administrative process associated with that is administrative. That's not handled by the judicial branch, that's handled by the executive branch. It's administratively handled by probably someone in personnel or HR. And they initially make that call. As was explained by Mr. Robinson, it is something that maybe should be looked at in terms of the retirement system. That the reconciliation of eligibility is not done till later. So have this board handled cases where somebody has been in the system and made payments and employers made payments and later deemed to be ineligible? Absolutely, and I'm sure there'll be more in the future. It's cumbersome and it's sloppy and it's unfortunate for the recipient to learn that information when they're about ready to receive a pension. So clearly that process needs to be evaluated for the system to do a better job upfront qualifying an individual. But I don't think and I'm just reading your response and expression about that it's black or white and the city put them in, they felt they were eligible at the time, 20 hours and that was it. So it's really 20 hours and above for pension eligibility. So at the time, that may have been the understanding of a given municipal employee at some level of HR that would have had that initial conversation with someone here in the retirement system, in my experience.
Add one point to that too, and just to be clear, I know I mentioned this earlier, but the statutory authority to determine who are employees within the meaning of the chapter is this board. So whatever happens at the at the city level, when a decision is made 20 years ago as to whether or not to begin deducting contributions for a particular person is not dispositive of, the analysis should be done by this board in terms of making that decision.
I guess I think I should respond, right? Like, if I get to these, so Karpinski said no. Because the HR director said they weren't working enough hours, the HR director. The HR director is also the one that, an older one, enrolled them earlier. So I don't think those are the facts, right?
Yes,
Okay,
yes.
I'm fine. Thank you.
This part, Ken.
Can I just say that you had mentioned that it is up to the pension board to determine eligibility? And what the judge did is she followed the procedure of the pension board, which is to take your case further. And in following the procedure, she met with our hearing officer who made a decision. And in my mind, I just don't feel comfortable with reversing his decision because I feel he had access to far, far, far more information than we're being presented in an hour.
Can I make one last point?
Please.
My client was issued weekly paychecks showing the quantity of hours she worked was 35 hours per week.
And
that was
have them all.
That was submitted as an exhibit to Mr. Cazzione when he made his consideration. So this representation by Attorney Regassa that, well, municipal court judges, well, the job isn't that difficult, doesn't require that much time. Well, then, if that's true, then why was she issued a check for 35 hours, showing payment of 35 hours per week? We believe in deference to, and following up what Ms. Paquette had to say. Cuzzione was the hearing officer. He had consideration of all of the exhibits in the matter. His decision should be accorded the deference it deserves, and you should approve her application for pension benefits. Thank you.
Any further comments from the board? Please.
I have a question for Attorney Robinson. So is there any relevance? Can you elaborate on the relevance of the fact that both the employer and employee throughout the term of Ms. Nesselbusch's employment, both employer and employee contributions were made?
Sure.
I understand Mr. Nada's point that that is not necessarily conclusive, but it also seems as though there was no job description of any type until somewhat recently. So in the absence of any clear indication from any earlier points of her career, should we be putting any weight in the fact that contributions were made all along? To Mr. Regassa's point, he said you don't just pay a bill blindly. that provided feedback to Ms. Nesselbush throughout the term of her employment that she was contributing, employer contributions were being made on her behalf. That seems relevant in the absence of any additional communication.
Yeah, the best I can respond to that question is to say that the processing of contributions does not involve a qualitative analysis of whether or not the person is appropriately a member of the retirement system or not. In other words,
Qualitative by whom?
well, that's the point, right? I mean, so when something happens 20 years ago and the error gets compounded because nobody corrected it over the course of 20 years.
Just what you're saying. So you're saying nobody in the retirement board is qualitative, like, because you don't know what the city did, right?
Well,
You're not trying to suggest what the city did. You're trying to suggest what the retirement board did.
Well,
right?
100%, because at the end of the day, it's the retirement board. The retirement board is the only body that matters in terms of making the final decision. But when the city was asked by the administration of the retirement system to comment upon whether or not this person is in fact working 20 hours a week or not, because that's part of the reconciliation that goes into making sure that the person is in fact retirement eligible when they apply to retire. Should it happen earlier? Maybe, but the reality of it is that when the person goes to retire, a number of things get checked by the retirement system. And so if an error had been made for 20 years or for 10 years or whatever, it was caught at that time. And the question is asked then of the city, should this person have been, did they in fact work 20 or more hours a week? And the answer comes back unequivocally no. So then they go to the next level and say, okay, do you have a job description? And it's just, okay, well, here's a job description that I prepared. Okay, does anybody at the city vouch for it? Can you get confirmation or corroboration from anyone at the city level? The answer, no. Then you get a letter from somebody, from an attorney representing the city saying, no objective evidence suggesting this person works 20 or more hours a week on a regular basis. The retirement system, as you know, is going to have a difficult time administering this issue across municipalities. If judges, the hearing officer's decision in this case was primarily based on the legal concept that only the judges get to decide what it is that they do, so that they can determine whether or not they're pension eligible or not subject to verification by any other coordinate branch of government. That presents a real issue in terms of administration for the retirement system, I would submit.
As a follow-up, are you saying that if we were to imagine this case as Ms. Nesselbush nor Pawtucket, neither of them made any contributions, and now after the fact, she's claiming eligibility for a pension, would the facts of the case be similar?
Absolutely. And I also submit too that I don't think it's that uncommon. I don't know if I can ask Andy, because he's brand new to the job, but I don't think it's that uncommon that errors are made in the taking of contributions that are corrected at the time somebody goes to retire. It's not common, but it does happen.
Has anybody from the city offered an alternative job description other than the one that Ms. Nesselbush provided?
No.
All right, so Cicero,
It's for Mr. Robinson. So you said that there was no evidence that she worked over 20 hours a week.
Other than her own description of what it is that she did, yes.
The flip side to that is, did anybody ever say that there's evidence that she did not work over 20 hours a week?
The formal pronouncements from the city's HR department.
Which was just the time on the bench, if I'm correct.
Based on the website.
Yeah, I mean, that's.
oh, did you have a question?
Sure.
Yeah.
Yeah, let me follow up. If I could follow up Mike's question. So, in my experience as a municipal official, in a number of different communities, we also go through the same process. Our town council, town manager form of government, a little different than a mayoral strong mayor city. Where our council actually, approves of and appoints our judges, municipal and probate. But I can say that there is absolutely and distinct separation from that point forward, where the administration, I'm an appointed official, have really all oversight. A couple of years ago, we made, based on a recommendation that I made to the council, their ultimate authority in terms of compensation, salary, benefits, typically emanate from the municipality and the administration. So the core hours of work, someone like myself, in our system at 35 hours, clearly in my job, I work more than 35 hours, but I receive credit for the 35. I don't receive more credit. I'm a salaried employee, just like the judge, for lesser hours. I don't receive credit for all the other things that are required of me in my position, nor would a municipal court judge or probate court judge receive credit. And I think this affects a lot of people in the room, right? For the extra 20, 30, 40 hours a week that many in this room probably work, you don't receive extra pension credit for that. So for me, this is a very, the noise is deafening, the white noise with this case. And I'm disappointed, Judge, you even have to be here. I am, because it's a sloppy matter, and I think we all need to learn something from this and clean it up in as many of our member communities as possible before this type of case happens again. But at the end of the day, it's as simple as, is there sufficient evidence that the judge worked 20 core hours in that role or not? The whole fairness question, the narrative is tough to process for a committee like this, right? It's very challenging, because I think there's truths in a lot of places and a lot of information that we've heard. But as Mike has tried to articulate, it's as simple as, do you qualify or don't you qualify? So that's where I'm just explaining kind of where I am in terms of processing all this information from all the parties that have presented information today. It's that simple. It's not a fairness question, and I know that's hard for a plaintiff who's sitting there, who has worked their career and has contributed, and for the employer as well who's contributed. But I think it's important for the committee to focus on, however you see it, on the technical nature of qualifying for eligibility, and did you work the hours or not? So that's a statement. I'm not looking for a response, but I'm processing, I think, as everybody is here and struggling through the narrative and all of the information and the 1,500 pages of evidence that we had in our record to process for this case. But I think it's really important that we look at that simply. And at the end of the day, the decision is going to get made, and I'm sure not everybody in the room is going to be happy with the decision, but I think that's kind of where I'm at this point in the discussion.
All right, 2 more questions and then we'll get.
Yeah, I'm just having trouble with. We can't say that she worked more than 35, I'm sorry, more than 20, because there's no evidence of that. The only evidence we have of it is what's on the website. That's like saying that the hearing officer only worked 8 hours because he heard 8 hours of testimony and not went into writing the decision. And that's why I asked the question about deference at the very, the onset of all this. That hearing officer sat there and determined that there was sufficient evidence that she worked for 20 hours. Just having a real tough time trying to not pay deference to that.
Thank you, Chairman. Attorney Robinson, I just have one question. One of the facts that's been asserted down here is that, like, no judge in the past in Pawtucket's been denied pension. Do you guys agree?
So there was, other judges in Pawtucket apparently were allowed to contribute, and some of them apparently retired. The facts of those cases and whether or not the retirement system analyzed anything having to do with them or not was not before the hearing officer. Just the fact that some were permitted apparently to retire. So it's hard for me to comment on it because, again, the facts of those cases were, did the retirement board make a mistake? Did they not analyze the actual facts of the individual cases? Did it just overlooked? There's a gazillion reasons as to why it might have happened. The facts of those cases were not before the hearing officer. So it happened in some cases, but how much weight to attribute to that is, I just can't comment on.
I just
Last
have a
question, Sandra?
question. You said that you have the paycheck stubs indicating that you were paid for 35 hours per week. Is that every paycheck, or is that?
Every single one.
So every single paycheck said that you worked 35 hours. Why are we arguing this?
Well, just to respectfully, nobody would believe that a municipal court judge worked 35 hours a week. That's.
Her paycheck
I understand, but that's the whole point, is that it's missing the qualitative analysis that we're talking about here.
If we're talking about qualitative analysis, we're into facts right now. We've come down to facts.
But in looking at a payroll stub, you need to also validate the hours, the hourly wage that's being tied to that. It's probably less than minimum wage based on what the judge was earning at the time. So if we're gonna talk about the 35, I'd love to see or understand what the hourly wage is that's being represented on that pay stub.
And that's largely why the issue was flagged at the retirement system level, quite frankly, is because you had these hours that are being reported with a $16,000 annual wage. So the system catches that when they're validating the account. and it looks way out of whack.
All right, last question. It's Tui. The last question.
Okay. Just for clarification on my side, when you were originally hired. Was there an hour stipulation or a salary stipulation? As far as how much you would be working minimum or earning maximum?
Oh, yes,
And how much, so that was all stipulated,
yes.
okay? Was there a maximum number of hours that they allowed you to work? Where you, or did you just do the job as you saw fit to do the job in an efficient and productive manner?
I was told that the job was at least a 20-hour-a-week job, could be more depending on the, requirements. That it came with a small salary at the time of about $16,000, which increased to $25,000 when I became the chief judge. And I do want this committee to know that in all my 20 years, I never once asked for a raise. This was public service for me, including the fact that my law firm had to hire additional lawyers to allow me to engage in public service. But I was told that it would be at least 20 hours a week, maybe more, $16,000 a year approximately when I was hired, and that the job was pension eligible, came with the pension.
So you were not working on an hourly basis, you were working
Correct,
on
it
a
was a
stipulated salary.
Salary
And you
position.
put in the amount of work necessary to do the job as you think it should be done,
Yes, sir, every week.
okay? So,
See your moment.
Yeah.
never mind.
We're all there.
Okay, but at this point, but I think that's the main point. Right there. Oh, that was what I was gonna ask. When you accepted the job, okay, did you write a letter of, yes, I want this job?
There was an application process. At that time, the job actually, there was an application process. It was 20 years ago. I can't really remember whether I wrote any, formal letter accepting it or not. There was a whole ceremony, there's a whole swearing in ceremony, there's a whole,
Who swore you in?
Mayor Doyle.
So the mayor
Mayor
swore you in, and when you, I believe, have you resigned from the position at this point?
Yes, after 20 years, and after the pension issue was resolved, I finally retired just last year in February of 20.
Congratulations. Who did you send that letter to saying that you were going to be resigning?
The city council, the appointing authority.
So that doesn't help at all. Okay, so thank you very much.
All right, I think we've had sufficient question and clarifying questions. I think it's now up to the board to make a decision whether to take Attorney Robinson's direction of overturning the hearing officer's case or upholding the hearing officer's decision. So what's the pleasure of the board? You guys want a 2-3 minute break? If you can think about it.
I move that we accept the decision of the hearing officer in this case.
That's a motion to accept or to hold the decision of the hearing officer. Seeing that right?
Yeah, I think it's articulated correctly, sure.
Is there a second?
I'll second that.
Second? All right, roll call?
Treasurer Diosa,
No.
Gene Rondo,
No.
Mark Carullo,
Yes.
Michael Cicerone,
Yes.
Joe Padiga,
No.
Matthew Howard absent, and the absent, William Murray,
No.
Andrew Nada,
No.
Alan Palazzo,
No.
Sandra Peckett,
Yes.
Dr. Shaw Hughes,
Yes.
Michael Tui,
No,
Jonathan Wilmer.
Yes.
It was a tiebreaker somewhere, right?
I don't know how many.
So no's win. So that motion
What's
fails.
the count?
What was the count of it?
I have
Five, so.
1, 2, 3, 4, 5, yes. 1, 2, 3, 4, 5, 6, 7, no.
Okay.
There's 12 voting.
Is there another motion?
If there's going to be a motion made to overturn the hearing officer, I would advise the board that I think it should be couched in terms of finding the hearing officer's conclusion that Judge Nesselbush in fact worked 20 or more hours per week for the entirety of her career to have been clearly wrong, and that the objective evidence, as the board heard it, does not support a claim that she worked 20 or more hours per week for the entirety of her career. That's the concept in which I would recommend the board make such a motion if that's the board's pleasure.
It's the pleasure of the board.
Like you feel that's satisfactory on that one specific point.
Well, yeah, I mean, I think that's right. I think the board needs to find is if they're gonna overturn the hearing officer, then the board is in fact is finding as a fact she didn't work the 20 or more hours per week. The hearing officer was wrong on that point.
But focusing on that one technical point.
That's the only issue in the case. That's it. That's the only issue in the case. There's no credibility findings. The hearing officer found both witnesses to be. It's an assessment purely of that question of whether or not she met the statutory threshold.
And this is a required step to overturn the decision.
Yes.
So
Yes.
Aren't you making fact finding here? You're making a determination. You've already denied her motion or the motion of the hearing officer to accept the pension application. Aren't you going further than that and actually making certain findings that are not within your purview?
No, that's not, yes, it'd be a fact finding, but it is 100% within this board's purview. This board is the sole authority that gets to make the decision of whether or not someone meets the eligibility threshold of being an employee within the meaning of the statute. That requires board to find, if they're gonna say no, that she doesn't work 20 or more hours per week. That's the issue in the case, as I see it.
The TUI,
Just a question, I believe, and correct me if I'm wrong, that the judge was under contract for 20 hours.
No contract,
No contract?
Verbal.
no contract, Mr. Tui.
Because I didn't want to go.
I
Okay,
think verbal contracts, well, you won't read it for a while.
okay, thank you.
all right, I think there's been sufficient discussion. Is there a motion on the table?
Sure. So I'll make the motion that board overturn the decision of the hearing officer regarding the element associated with the judge in the position with Tuckett courts having worked 20 hours per week, securing eligibility for a MERS mention. So.
Second by
Discussion.
Al, discussion?
So if we vote yes on this, we're saying that it is a fact that she did not work 20 hours per week. Yes.
Correct. There's insufficient evidence to support that claim of membership.
Either is insufficient evidence or we're saying it's a fact that she did not work.
Well,
Your original statement said that we are saying it's a fact that she did not work.
Yeah, one person.
Your decision can only be made on evidence, right? Based on the evidence that's before you. The question, the legal and factual question is whether or not the person met the eligibility threshold for membership in MERS. In no scenario can someone be a member if they don't work 20 or more hours per week. This board, if they're going to find that she is not eligible for membership, should be based on a finding that she doesn't meet that 20-hour per week requirement. That's what I'm counseling the board, is that the decision needs to be based on that factual predicate.
Wilmer?
If the board isn't able to reach resolution here, what's the default? What happens?
Two responses to that. The regulations provide a mechanism for resolving a tie vote of this board. And in that scenario, if there's insufficient yay votes on a given motion, it gets postponed to the following board meeting when there will hopefully be a larger complement of board members. That's in the reg in the event of a tie. If in the event that if there's no resolution as a result of that mechanism, the underlying administrative decision of the executive director stands.
Okay, so it doesn't go to the hearing officer's finding,
No.
that's just a recommendation.
Well, this board can send anything to a hearing officer that it wants to. The hearing officer is supposed to be helpful to you.
Yeah,
So-
but that more or less it's advisory.
Correct. It's a recommendation. That's it.
So if it's a recommendation, then, yeah, okay, so that helps me explain why you think there needs to be a finding that, you know, that working, the.
Hearing officer was wrong.
Well, but if it's just recommendation, then you need us to find that the judge worked 20 hours. Because the hearing officer just advisory, is that what you're saying?
Yes.
Okay, I mean, that makes a little more sense to me, that we're not overturning the hearing officer. We are just, that's a recommendation of advisory.
You're not accepting the decision of the recommendation of the hearing officer. You're finding that he was wrong on that, to the extent that he found that she worked 20 more hours, and this board is making a finding that she did not. Does that make sense? Okay. We understand the procedural question.
All right, so there's a motion and a second. Billy, last-
Just, what is the next step if we vote to agree on the motion? Is there a next step or is
The judge would have the ability to seek judicial review under the Administrative Procedures Act.
okay,
If the board said she's eligible for membership, which that motion just failed, the board's not going to appeal itself. So the board, whatever the board says is the
Right.
board's official action. An aggrieved member has the ability to seek judicial review.
that's it, thank you.
motion, there's a second, we have a roll call vote.
Treasurer Diosa.
Yes.
Gene Rondo.
Yes.
Mark Rulo.
No.
Michael Cicerone.
No.
Joe Codiga.
Yes.
William Murray.
Yes,
Andrew Nada.
Yes.
Alan Plazzo.
Yes.
Sandra Beckett.
No.
No.
Dr. Shaw Hughes.
No.
Michael Tui.
Yes.
Jonathan Woolman.
No.
Five no's and 7 yeses, so the motion passes.
Judge, you will receive official notice of the retirement board's administrative action today, triggering your right to judicial review should you wish thereafter to seek it.
I'd say thank you, but I'm not sure that's exactly the right salutation.
Thank you.
Very good.
All right, take 3-minute break.
Yeah, it is.
So
To you.
last
I had.
All right, we are back on. All right, we will continue moving on the agenda. The next item is the approval of the October 2025 pensions as presented by ERSRI. But there is one thing regarding Matt Howard's request that we're gonna ask to.
This is, nope. this
Oh,
is
the
the
disability,
retirement.
sorry. Right.
Motion to approve.
Motion to approve, second, all in favor?
Aye.
Aye, so moved, sorry about that. All right, legal counsel report.
So you have the litigation reports with you. The one matter I will highlight is the Patricia Dubois matter, which was an administrative appeal. We received a favorable decision from Judge Lanfair upholding the retirement board's decision in that matter. Final judgment was entered. The appeal period will run shortly. Assuming no appeal, that matter will be removed from future reports.
All right, we move on to committee reports. The disability committee.
Not
I think so.
Yeah, okay.
So, at the last meeting, board member Matt Howard, pulled out the Kevin Ansley matter for further discussion. It was tabled at the October meeting. I believe because Mr. Howard's not here today, we're going to seek a motion to table the Ansley decision once again for the, and place it on the December meeting.
So move, second, all in favor?
Aye.
Aye. Okay, motion was table that item.
So but I'll make a motion to approve the disability committee recommendations from our November 7th, 2025 meeting, numbers 1 through 7.
Second. All in favor?
Aye.
So moved. Thank you. We will now move on. No items? Certainly.
Is that
It's gonna adjourn. This is.
Well, we just weren't comfortable, come on. What do you want, got a luncheon date?
Yeah, motion by Bill, second by Al, all in favor?
Aye.
Thank you. It's a climatic, huh?
Good job. Enjoyment went up.
Yeah, yeah.